Well, hi everybody, it's Rob Dawalt, and I'm here to give you a little bit more content on this whole point about copyrights, patents, and trademarks. One of the things I want to share with you is that we've already talked about this a little bit, poor man's patent. It's usually a pretty good practice, even if you do plan to use all the technical legal aspects of like the patent office or the copyright office or any other method like that. It's not a bad idea to print off a set of plans or a solid description, or if it's music, for example, a complete set of the lyrics and music and so forth for a song that you came up with, and mail that to yourself. And you don't open the envelope after it comes back. You just keep it. You keep it in a safe place, like a home safe or somewhere. And basically that whole point of that is that when you would get in a dispute with somebody where maybe they're trying to steal your idea, because patents and copyrights take months to be approved by the government. So if you have that idea, you lock it in, you mail it to yourself, and then you just hold on to it. That's just some basic advice that a lot of people use. It's called a poor man's patent. And really what it does is it just proves that it was your idea, that you mailed it to yourself, and if you get into court, then that's when you would open the envelope, is the day that you're in court, and you would show, well, this is where I came up with this, and so the judge would be able to see, yes, that's true. Well, first of all, let's talk a little bit about what is a copyright, and that is a form of protection for the authors of original works of authorship, and this includes literary works like books. Like I said earlier in one of my posts, Charles Dickens was subject to some of the most terrible theft of his ideas back in the around the 1860s and thereafter, because people in the United States did not recognize British copyrights. And so there was no international copyright agreements. And so he had a bunch of books. Of course, they're all in English. They come into the United States. And people in the United States start stealing them and publishing them in these little dime novels or small, kind of like what we would think of as a comic book. They had a lot of that type thing, even though it might all be black and white, in the mid-19th century. And so he came on a tour, a speaking tour of the United States about all of his different works because he was very popular. Well, lo and behold, the people were all buying the books at newsstands and places where he was not getting any royalties for all these books, and he became really outraged and left the United States in disgust because he had, had all these people basically stealing his material. This was clear back in like 1870. So it's a long time ago, but this has been a problem off and on of people stealing other people's ideas. Also music, drama, arts, artistic items, intellectual works. Note, for example, the song Happy Birthday that's mentioned. That's been around for a long, long time, written by two little maiden ladies that taught elementary school in Kentucky, and first wrote it as good morning to you, good morning to you. We're all in our places with bright shining faces. Well, then they altered it to be happy birthday to you, happy birthday to you. Now, I'm not going to butcher it anymore, but you get the idea. The problem, if you go into a restaurant today, there has been for a long time an argument that if you allow people to sing happy birthday in your restaurant, then you have to pay a premium, maybe a few cents, to a company that marshals all these different songs and the royalties and make sure that the people that own the copyright to these different songs gets a check. So you ask yourself, well, why was that T-bone steak so expensive? Well, because somebody in there, whether when you were there or somebody else was there, sang happy birthday, And so all that is passed on to the consumer. And so singing the happy birthday song netted this company over $1 million every year in restaurants. So very important. Now there's a big lawsuit involved. There's a question about which way it's going to go. It's been this way for a long, long time, so it's hard to say what the outcome's going to be. But what happened was there was a copyright. It was renewed, so the family has gotten proceeds for a long time. Finally, they sold it to someone else. I think it was like Warner Brothers, and then Warner Brothers sold it to someone else. So it's been around a long time. Okay, well, trademark or service mark. Now this is a little different. It's a word, name, symbol, or device which is used in trade with goods to indicate the source of the goods and to distinguish them from the goods of others. Service mark is the same as a trademark, except it identifies and distinguishes the source of a service rather than an item. So trademark, mark, you often see this out, maybe TM next to the title of a certain product. And then patents are still another thing, and that is more for an invention. The term of a new patent is 20 years, basically what that means is someone comes up with an invention that belongs to them for 20 years, and then also the patent can be extended, and one of the things that you get into is China, for example, modernly is kind of doing the same kind of things that the U.S. was doing when it was a kind of a baby nation, like a new country, and was stealing ideas from Charles Dickens. Well, China is doing the same thing from a lot of our inventors and authors and so forth, musicians, stealing these things and generating copies in China and selling them back to us for very low prices. You usually find these at places like flea markets and places like that. They basically flood the country with a lot of cheap goods like watches and purses and t-shirts and all kinds of things that were originally dreamed up by someone else. And then, of course, another thing that people want to do is oftentimes they'll make slight changes. So this is where the litigation comes in. People will come in and make a slight change to a slogan, title, commentary, a song, or some kind of an invention, and then they get tangled up in litigation. But some people, since they're offshore, you're wasting your time to try to litigate with them because they're hiding offshore in China or somewhere. So it's a big problem. It's very bothersome for a lot of people. So basically, these are the different items. Clothing items a lot of times can be trademarked or copyrighted depending on the circumstances. For instance, if you silkscreen an original idea on a t-shirt, like a smiley face, for example, whoever did that, then you would be able to get at least a trademark on that. So you would be able to put a little trademark sign next to your item, like your smiley face. Some things, though, that you get into, like the pet rock, for example. Come on. So where does it end? What is worthwhile? You get a rock, you polish it a little bit, maybe and put a coat of veneer on it or something, polyethylene or whatever, put it in a box, mail it to somebody. Come on. A guy was a multi-millionaire that came up with that idea. So these are three different things. They're all somewhat different. They're all similar. Keep in mind the comments that I made here. Once again, I'm saying we're getting down to the end. If you have a need, pick up a few points, and you want to write a short paper on comparing these three items, I would consider that to give you a little bit of makeup credit for some things that maybe you missed in the past, or if you didn't do well in one of your tests or something like that. So this is just a suggestion. Make sure that if you do write a paper, be sure to follow all the rules in terms of APA, cover page, references, and all these type of things. So thanks very much for watching. That's my presentation for today on copyrights, patents, and trademarks. Thank you.